Okay. This guy's name is John Parks Trowbridge. Now, we talked either last week or the week before last about the difference between the District Court of the United States, which is a Article III court, a constitutional court, and United States District Court, which are territorial courts. The United States District Courts get their authority from Article 4 of the Constitution. District Courts of the United States get their authority from Article 3. Article 3 is the one that we need to be in.
Welcome to the Institution for Higher Learning and Common Law. This is January 22nd, 2016. This video is an update to the Trowbridge 1 video that deals exclusively with the District Courts of the United States compared to the United States District Court. If you'd like the paperwork from this video, if you'll click the link down below and sign up, we'll send you the paperwork. Brad, go ahead and take it away.
Thank you, Joseph. As he said, we're dealing with two different types of courts, and I'm going to try to explain to you the different courts because they have different jurisdictions. The Federal District Court, the trial court where we take our grievances that fall under the jurisdiction of Article 3 of the Constitution, is actually split into two systems. One is to be utilized in the 50 states of the Union, and the other to be utilized in the District of Columbia and the territories, federal enclaves, and insular possessions of the corporate United States. The court that is supposed to be in the 50 states of the Union is the District Court of the United States, which are established by Article 3 of the Constitution. My research shows that only the federal court in the state of Hawaii was established pursuant to the provisions found in Article 3. If you will go to Title 28, USC, Section 91, and look in the notes section, you will find this sentence, quote, "The United States District Court for the District of Hawaii, established by and existing under Title 28 of the United States Code, shall thenceforth be a court of the United States, with judicial power derived from Article 3, Section 1 of the Constitution of the United States," end quote. The other 49 states are listed in alphabetical order, beginning with Section 81 and ending with 131. If you choose to, you can go to the notes section of each of those sections, and you will find that there is no mention of their being ordained by Article 3. Article 3, annotations. Section 1, the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation, which shall not be diminished during their continuance in office. Section 2, the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. I'm going to break away from the text for a minute here because we're dealing with two words that most people don't understand the meaning of. The first word is law. The term law here means the common law, whereas the term equity refers to a chancery court. Back to the text. To all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens or subjects, close quote. So when we enter into a federal building in any of the 50 states of the Union, we should find district courts of the United States. Sadly, we do not. In reality, what we find there is United States district courts, and they are not the same at all. United States district courts are created by Article 4 of the Constitution and are legislative courts and are to decide cases in the territories, federal enclaves, and insular possessions of the United States. Here is what the Constitution has to say about Article 4, Section 3. The Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. And nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. The Supreme Court of the United States has made rulings on this topic from two different perspectives. One from the perspective of the District Court of the United States, and the other from the perspective of the United States District Court. I will speak of two of those rulings here because they seem to be the clearest to the layperson. Balzac versus the people of Puerto Rico. Quote, the United States District Court is not a true United States court established under Article 3 of the Constitution to be administered through the judicial power of the United States therein conveyed. It is created by virtue of the sovereign congressional faculty, granted under Article 4, Section 3 of that instrument, of making all needful rules and regulations respecting the territory belonging to the United States. The resemblance of its jurisdiction to that of true United States courts in offering an opportunity to non-residents of resorting to a tribunal not subject to local influence does not change its character as a mere territorial court. Nor does the legislative recognition that federal constitutional questions may arise in the litigation in Puerto Rico have any weight in this discussion. The Constitution of the United States is in force in Puerto Rico as it is wherever and whenever the sovereign power of that government is exerted. This has not only been admitted but emphasized by the court in all its authoritative expressions upon the issues arising in the insular cases, especially in the Downs and Bidwell and the Dorr cases. Please note that the Supreme Court of the United States emphatically states here that the United States District Courts are Article 4 courts and created for the express purpose of adjudicating within the territories and other possessions of the United States. It further states that the District Courts of the United States have authority whenever the sovereign power of that government is exerted. This is yet another indicator that their authority is in the territories, as the United States does not have sovereign power within the 50 states of the Union. Compare with Mucchini versus the United States. Quote, the term District Courts of the United States, as used in the rules, without an addition expressing a wider connotation, has its historic significance. It describes the constitutional courts created under Article 3 of the Constitution. Courts of the territories are legislative courts, properly speaking, and are not district courts of the United States. We have often held that vesting a territorial court with jurisdiction similar to that vested in the district courts of the United States does not make it a district court of the United States. Close quote. The really sad and frightening thing about all of this is that the government of the United States knows full well that this is true, that our federal government is and has been attempting to make us believe that they are sovereign here, that the federal laws apply here, and are not just relegated to the federal enclaves carved out of the states of the Union for the purpose of erecting forts, arsenals, magazines, dockyards, and other needful buildings. You'll find that definition at Article 1, Section 8, Clause 17 of the Constitution. Simply what this means is that if you have had any dealings in a United States District Court, unless you are in a territory, federal enclave, or an insular possession, the court didn't have jurisdiction. There is no statute of limitations on a jurisdictional question, so you can file your paperwork at any time. There is an answer. The main job description of the legislature of your state is to protect the people within that state from the encroachment of the federal government upon the rights of the people. Let's hold their feet to the fire. They must do something other than look for a photo op in order to get reelected. Go to our website at Institution for Higher Learning and Common Law.com and see what we're doing about it. If you consider yourself a freedom lover, an oath keeper, and/or a patriot, join us in the fight to retake America. Good night.